This video is going to go through the various aspects of the Office of Special Counsel, or OSC for short, that are important for you. OSC's primary responsibility is to protect federal employees and applicants from prohibited personnel practices, especially reprisal for whistleblowing. OSC's headquarters are in Washington, D.C., and the agency has several field offices out of which investigations are conducted. There are 3 different divisions within OSC that are going to be relevant to you. First is the Case Review Division, which serves as the initial point of intake for all OSC complaints. Staff in this division screen all new complaints, and if the case meets the basic legal requirements for OSC to work on it, the case is sent for investigation. The new case will then be transferred to one of OSC's Investigation and Prosecution Division offices and will be assigned to an attorney to begin investigation. At any time during the life of the case, an investigation attorney may refer the case to the Alternative Dispute Resolution Unit, or the ADR unit, where it can be mediated.
Let's run through a few example scenarios to show you what the process actually looks like. First, the Case Review Division transfers a case to one of OSC's Investigation and Prosecution offices. After conducting an initial review to make sure the case meets certain standards, the investigation attorney may send the case to the ADR unit to assess if it's right for mediation. Once a case is in investigation or is in the ADR unit, it doesn't necessarily stay there. For a variety of reasons, cases can be sent from the ADR unit back to the investigation attorney, and vice versa. Eventually, there will be an outcome, whether it be the case is dismissed, the case is settled, or there is a finding for the complainant.
Now, within either the ADR unit or an Investigation and Prosecution Division, there are different potential outcomes. Within the ADR unit, parties either settle or they don't. In cases where they don't settle, this could be because one party withdrew from the mediation or for a variety of other reasons. If a case does not settle in the ADR unit, the case is sent back to the investigation attorney for more investigation. Within the investigation divisions, the attorneys will investigate the complaint further and either seek relief for the complainant or close the investigation without relief. In some cases, investigation attorneys may help the parties settle the complaint. Now we're going to go over the mediation process in a little more detail. As we've already discussed, first a case is sent from an investigation attorney to the ADR unit for an evaluation to determine if mediation is right for both parties. Mediation is completely voluntary, and both parties will be contacted and asked if they would like to participate. Sometimes the ADR unit staff calls one or both parties to obtain information that they need to decide if mediation is right for your case. If both parties accept mediation, you will both go through a process called pre-mediation. Here, a mediator from the ADR unit will talk to you about your case. They will go over 3 main things. First, they'll give you an overview of how the mediation process works and what to expect. Second, they'll ask you some questions about your specific case so they can make the mediation work for you. Third, they will go over a few logistics for your mediation, such as when and where. The mediators will also go through the same steps of the pre-mediation process with the other party. After the pre-mediation process, you'll have your mediation. This is when you'll either sit down or talk by video or telephone with the mediator and the other party to see if you can reach some sort of agreement. Either party may stop the process at any time. The case will then be transferred back to the investigation attorney.
So why go to mediation? There are a couple of reasons. First, it's a neutral process. The mediator is not on the complainant's side, and the mediator is not on the agency side. The mediator's job is to facilitate communication between the 2 parties to help them have a productive conversation. It is often helpful to have someone neutral facilitate the process of communication because that individual can help parties look at issues from the other's perspective and can keep the conversation on a productive course. The second reason to consider mediation is that the process can be relatively fast. If it's important to you that this process wrap up quickly, mediation may be an option. Although the timeline may vary depending on the specifics of your case, mediation is generally faster than other alternatives. Third, mediation can also be efficient. Because you'll be able to speak with the other party directly, you can work through the different aspects of the case much more efficiently. Fourth, and finally, mediation can lead to some unique solutions to the case and to the issues between the parties. The two parties can be as creative as they want in coming up with solutions that meet their interests. In conclusion, this video summarizes how mediations work at OSC and some reasons why mediation might be right for you. We hope that when considering OSC mediation, you remember that mediation offers a neutral third party to facilitate the communication process, that mediation can be more expedient and efficient than other alternatives, and finally, that mediation can help you and the other party work toward creative solutions.